I promised you that I'd never shrink from controversy on the Dershow, and today I'm really going to get into it because we're going to talk about the Breonna Taylor case and why police officers were not indicted for homicide in the death of Breonna Taylor. I will do a legal analysis as if this were a law school class. I'll lay out the facts, lay out the law, and leave it to you to decide whether justice was done. And then I'm going to surprise you because I'm going to tell you about one person who could theoretically be indicted for her murder. And you'll be shocked when you find out who it is. The great Justice Oliver Wendell Holmes once remarked that hard cases make bad law. And that may be true, but public demands for justice, although they're constitutionally protected and often very desirable, also make bad law. Today, we're going to talk about the Breonna Taylor case, one of the most controversial cases, causing demonstrations and demands for justice, not only all over the United States, but all over the world. Are these demands for justice consistent with the law? I'm going to conduct a law school seminar. I'm going to treat the case as if I would treat it teaching first-year criminal law to Harvard Law School students. I'm going to analyze the case, deconstruct its legal and factual elements, and leave it for you, the students, to decide whether justice was done or not done by the decision of the Attorney General and the grand jury not to bring any charges against the police officers for the killing of Breonna Taylor. There were charges brought against one police officer for recklessly endangering the lives of 3 people who were in an adjoining apartment, and he fired, apparently according to the indictment, recklessly through a glass window or door that was covered with blinds, and he didn't have a sight line, and therefore he could easily have killed or seriously injured any of the 3 people. But that's not what people are really focusing on today. What they're focusing on is the decision, and a clear and firm decision, not to bring any homicide charges against any of the police officers who fired repeated rounds into the room in which Breonna Taylor and her boyfriend were watching television, and some of the bullets struck Taylor and killed her. And nonetheless, the prosecution and the grand jury decided to bring no homicide charges at all. Is that correct or is that incorrect? Let's begin with the undisputed facts, and then we'll get to some of the issues that might be hotly disputed. We know that the police had a no-knock warrant issued by a judge that authorized them to go to the apartment, announce themselves as police officers, use a battering ram, and break in and arrest and search the premises, arrest the people. The judge bears responsibility for that. And for 50 years of teaching criminal law and practicing it for even more than that, I know that judges hand out search warrants and arrest warrants and even no-knock warrants like Christmas presents on December 25th. It's so easy to get a warrant. Judges don't take the time. There have even been cases where judges on their desk have signed warrants and the police officers just pick them up and implement them. So if there's going to be any responsibility for the issuance of the warrant in this case, the no-knock warrant, it lies squarely with the judge, not the police officers. The police officers had a warrant in their hand. They were authorized to do what they did. Now, it's not controverted, not disputed that they had the warrant. There is dispute about whether they announced they were police officers effectuating the warrant. Apparently, one neighbor says he heard them announce that they were the police. Other neighbors say they did not hear any such announcement. The prosecutor said he believed that such an announcement was made. If you listen to the 9/11 call from the boyfriend after the shooting, it sure doesn't sound like he believed that there were police officers. It certainly sounds like he believed there might have been intruders and that he was engaged in an act of self-defense, defending others, that is, defending his friend and defending his property, which under the law is permissible. But that is disputed. And whether the grand jury heard evidence on that, Whether they made a plausible decision, we'll only learn later when we get more information. Right now, we are really, really lacking information. I haven't seen, I looked all over the internet, I haven't seen grand jury hearings. Those are secret, but those can be revealed if you get permission of the court. I haven't seen an extensive, detailed report of what happened. There's still disputes about whether or not a search was conducted after the shooting. Remember that, to go back to the facts for a second, once the battering ram was used and the entry was made, Breonna Taylor's boyfriend fired a single shot in the direction of the police officers, who he claims he didn't know were police officers, seriously injuring one of them, shooting them in the leg, in the thigh, in the artery, which of course bleeds profusely. And the police had to focus a lot of attention on rescuing him, putting a tourniquet on him. And by one account, I've heard that there was no search conducted, and so we don't know whether there were drugs in the house or not. By other accounts, maybe a search was conducted and they found no drugs. Again, undisputed, there were no drugs found. Whether they weren't found because there was no search or because there was a search and there were no drugs, that again is subject to dispute. So we know that one shot was fired by Breonna Taylor's friend, and we then know that in response to that one shot, the police officers fired multiple rounds in the direction of the shot, several of which hit Breonna Taylor and killed her. And the question is, under the law, whether or not that's a crime. As the Attorney General correctly said, we all agree it's a terrible, terrible tragedy. This search should never have been conducted. No-knock warrants should not be easily granted. They should be only granted in extraordinary cases. And I have to tell you, if this were a drug search in a white middle-class or upper-class neighborhood for cocaine, I doubt that we would have seen a no-knock entry. I suspect we would have seen a very polite knock on the door or an advance phone call saying, we have a warrant, we'd like to search your home, please leave the home, go outside, we're going to go in, we'll be a short period of time, and if we find anything, we'll arrest you. If we don't, we'll let you go. The fact that this was a search in a black neighborhood of alleged drug dealers who were African American, I'm sure influenced the way the police operated in this regard. In my experience, we do have a double standard when it comes to police operations in black neighborhoods and police operations in white neighborhoods, particularly if the black neighborhoods are working class neighborhoods and the white neighborhoods are middle class or upper class neighborhoods. So we do have a double standard of justice. But does that affect the actual decision by the police to fire several rounds in the direction of where a round was fired and hit a police officer? People are not going to be happy to hear this, but the law is pretty clear. And that is, if police officers are being fired upon, even one shot being fired upon, they do have the right to respond by lethal force. They do have the right to shoot and protect their police officers. Was this an overreaction? Firing 20 some odd rounds in response to one round? The law doesn't really provide for that. The law basically says if you're fired at, you can fire. If we put this in a military context, this is not a military context. This is civilians shooting at American citizens, police officers shooting at American citizens. If we put it in a military context, of course, there'd be no dispute. If you're an American soldier with an automatic weapon and somebody fires a single bullet at you, you can respond by firing 500 bullets and killing that person. There's no doubt about that under rules of engagement in military law. The question is, do the same rules apply in the civilian context with police? And the rules that apply to police are rules of reasonableness. You see when you watch cowboy movies or you go on television, the good guy, the Lone Ranger, Hopalong Cassidy. I'm going back way into my past. Probably some of you don't even know who Hopalong Cassidy was. Great cowboy hero. Tom Mix, all those guys. They would shoot the gun out of the hand of the person with the gun, or they'd shoot him in the leg to prevent him from escaping. That's not the way it works in real life. Police are scared. They want to go home to their family. One of their police officers was shot in the leg, seriously injured. bleeding profusely, you're going to find the police will shoot. They will not shoot at the arms or the legs. They'll shoot at the torso if they can see the person firing the shot. If they can't see the person firing the shot, they will fire in the direction of where the bullet came from. That's what happened here, and that's why the vast majority of criminal law experts, prosecutors, defense attorneys, liberals, conservatives, Democrats, Republicans, said even in advance of this grand jury determination that it would be very, very hard, absent some damning evidence of an intention to hurt and to go beyond what was necessary to protect lives. Absent any of that, this was not going to be an easy case to get a homicide prosecution going. And so it's so important that the law be applied fairly. It must be applied fairly without regard to race, without regard to gender, without regard to ethnicity, without regard to wealth or poverty. And we shouldn't allow the law to discriminate against African American people or against poor people. But on the other hand, the law can't discriminate in favor of people who are the subject of protests. You have to apply the law to the facts. Now, we're entitled to more facts than we now have. We haven't really seen a great many of the facts that might change opinions about the law. The law is always a function of the facts. First come the facts, then comes the law. You apply the law to the facts. Often the facts are in dispute. And so prosecutors ask themselves, do we have probable cause? Do we have a reasonable basis for believing these facts? Could a jury, a reasonable jury, find these facts beyond a reasonable doubt? And if they could, then the law comes in, and the person is indicted for murder, manslaughter, any other kind of homicide prosecution. Or they could have been indicted for what the third officer was indicted for, recklessly endangering Breonna Taylor and her boyfriend. But that wasn't done. The only reckless endangerment charge was in relation to another family, a husband, a wife, and a child. So the question remains, should there have been an indictment? There may still be one. Remember, the fact that there's been no indictment doesn't foreclose the possibility of another indictment. There's no double jeopardy when it comes to indictment. Double jeopardy only applies when it comes to conviction. Moreover, the federal government is looking into this case. They conceivably might find, as they did in the Rodney King case, that there was a violation of Breonna Taylor's civil rights or the civil rights of her boyfriend. That would create federal jurisdiction and allow the police officers to be prosecuted. Indeed, double jeopardy, mistakenly in my view, but the law today is clear, double jeopardy doesn't preclude the state from trying somebody, acquitting them, or convicting them, and then the federal government coming in and trying them for exactly the same crime, as long as one is a federal crime and one is a state crime. The double jeopardy clause does not apply across jurisdictional boundaries. So you can have a prosecution by the state followed by a prosecution by the federal government, or vice versa, except in some states which have their own state constitutional protections, New York, against double jeopardy, even if there's a federal prosecution first. So this case is not over. The public is demanding justice. The public has the right to demand justice. The public has the right to go to the streets and engage in non-violent demands for justice. Attorneys general have an obligation to listen to cries for justice. But in the end, prosecutors must apply the law to the facts without regard to what the public demands. That's what justice is about. Justice must not only be fair, it must be seen to be fair. But seen to be fair doesn't mean giving in to what the crowds want. The crowds in this case would probably demand a first-degree murder prosecution against the police. That would not be justified under any theory of the facts here. Now, for one crowning irony, this will shock you and surprise you. There is conceivably a plausible case for a murder prosecution to be brought against those responsible for the death of Breonna Taylor. This will shock you. Who would be the defendant in that case? Her boyfriend. What? Her boyfriend, who tried to protect her, can be prosecuted and convicted of her murder? Yes. Under the absurd and anachronistic felony murder rules that apply in many jurisdictions, Pennsylvania being the leading jurisdiction for this kind of issue, if a person starts shooting and that results in somebody else shooting at the person and the person's friend or co-worker, the person who started the shooting can be held responsible under the felony murder rule for the death of the other person. The case grows out of the following situation. Two guys go into a bank to hold up the bank. They're both co-robbers of the bank. One of them fires at the police. The police fire back and kill the co-robber, not the guy who fired the shot. Some courts have held that the first robber, the guy who fired the first shot, is responsible for the death of the second robber, even though the bullet that killed him came from the gun of the police, because the first robber initiated the firing that caused the death. Is that going to happen here? I don't think so. It would be a bridge too far. It would be a stretch of the felony murder law, but it's just my way of illustrating the law is complex. It's difficult. It doesn't always follow conceptions of justice. Oliver Wendell Holmes once told his law clerk, when the law clerk came in and said, "Mr. Justice, this result is not a just result." And Holmes said, "We're not in the justice business, young man. We're in the law business." Well, one hopes that the law business is the justice business. If the law doesn't do justice, it will not long survive. The Bible says, "Justice, justice must you pursue." And commentators ask, why is justice mentioned twice? Why not just once? And there are many interpretations. Some say it's procedural justice versus substantive justice. Some say justice for the victim as well as justice for the accused. I leave it to you to give an interpretation to the biblical command to do justice. But one thing is clear. A legal system that doesn't do justice and a legal system that is not seen to do justice will not receive the credibility and the support of people who demand justice. So, justice for Breonna Taylor, yes, but justice also for those who might stand accused of her death. That's the complexity of our legal system. We must do justice to victims, we must do justice to the accused, and we must see that justice is done for all Americans under all circumstances, regardless of race. I know some of you will disagree. Some of you will say, you wish I had come up with an argument for why these police officers should immediately be indicted, prosecuted, and sentenced to life imprisonment. Look, I wish also I could come up with a plausible justification for vindicating the death of Breonna Taylor, but it has to be consistent with the law and the facts. And I just can't stretch the law, and I can't stretch the facts. Just as I was controversial when I opposed the impeachment of President Trump, a man who I voted against. I voted for Hillary Clinton. I was criticized for opposing his impeachment. I did it not because of politics. I did it because I studied the Constitution and came to the firm conclusion that what Trump was accused of by the House of Representatives did not constitute an impeachable offense under the Constitution. It was not treason, bribery, or other high crimes and misdemeanors. It was abuse of power and obstruction of Congress, which the framers of the Constitution essentially rejected as criteria for impeachment. The same thing is true here. Some ultimate form of justice, some heavenly justice, might say what the police did was wrong and they should be punished. But they can only be punished under the law and the facts. So let's demand more facts. Let's demand that we see grand jury proceedings. Let's demand that we see fuller police reports and ballistic reports and other reports and interviews with neighbors so that we can be comfortable that justice was done. And if justice was not done, it's perfectly proper and constitutionally protected to demand justice. This is Alan Dershowitz, and you've just seen a classroom discussion of the Breonna Taylor case on the Dershow. Now it's your turn to ask me questions. Remember, the questions need not be limited in any way. Ask me anything you want about any subject that's been on the show or that's on your mind. The first caller is John from California.
Hi, Ellen. My name is John. I was calling from California. I had a question since abortion has been an issue recently. I understand that we also have fetal homicide laws in our land. So I was just wondering how that kind of passes muster where, depending on the age of the fetus or who commits it, where, the termination of the fetus would be considered murder in some situations, but in other situations not, right? I'd be happy to hear, your legal explanation on that. Thank you so much.
You've raised one of the most difficult moral and legal issues. Consider the following situation. A woman is 7 or 8 months pregnant. She's desperate to have the child. She's happily married. Her husband wants the child. They've already picked the name. They have gotten the crib and done the furniture, and they're really into having the baby. And somebody who hates her, maybe a former boyfriend, comes in and says, I'm not going to let you have this baby, and kicks her in the stomach and kills the fetus. Surely that should be murder, even though it's a fetus. This is a fetus that was about to become a live person at the request of the mother. If not murder, it should be a very, very serious crime akin to murder. And it is in some jurisdictions. In California, a man was convicted and sentenced to death for not only killing a woman, but killing her fetus as well. So we have laws in a number of jurisdictions that permit that, but only under special circumstances. And they don't apply to abortions done at the request of the mother. That's deemed to be very different and consensual. Now, should a mother be able to consent to the abortion of her fetus? Reasonable people could disagree about that. But the moral issues are vague. The legal issues are vague. It's a great question. I love questions like that.
Howdy, Alan. Braze here. And I've noticed that there seems to be quite a bit of anti-Catholic bias coming from a lot of the Democratic quarters on this. Now, I looked up on Wikipedia, and I saw that there have been quite a few Roman Catholic judges on the Supreme Court. I would love to hear your opinion on whether you think that the court needs another Catholic on it, and what you think about the Democrats really just, hammering away at our papal brothers and sisters about this.
Great question. As you know, the Constitution prohibits any religious test for any office under the United States. So it would be unconstitutional to pick somebody because he or she was a Catholic, or to refuse to pick somebody because he or she was a Catholic. Some years ago, a senator said he would never confirm an atheist for the Supreme Court. Well, tell you a little secret. There have been a few atheists and agnostics on the Supreme Court, and it would be unconstitutional to deny somebody a seat on the Supreme Court because they didn't believe in God. That would be a religious test. I agree with you. I think we are seeing an increase in anti-Catholic attitudes in some quarters. I was appalled when Senator Feinstein, who I generally like, attacked Judge Amy Coney Barrett and said, the dogma lives loudly in you. Dogma. She was talking about religious views, deeply felt religious views. There was a time just a couple of years ago when the Supreme Court consisted of 6 people of Catholic faith and 3 of Jewish faith. Not a single Protestant was on the Supreme Court. Now we have Justice Gorsuch, who is Protestant, but the rest of the court is still Catholic and Jewish. Back in the day, there were no Jews on the court and no Catholics. Ultimately, there became kind of a Catholic seat and then a Jewish seat. But now I hope we're beyond that, and we would never and should never regard religion as a criteria or disqualification for service on the court. And Any anti-Catholicism should be attacked and attacked vigorously. We have a long history of anti-Catholicism in this country. John Adams and Thomas Jefferson wrote letters to each other about the danger of the Jesuits coming to America. The Know Nothing movement, the Klan, were virulently anti-Catholic as well as anti-black and anti-Jewish. So there's been a long history of anti-Catholicism along with anti-Semitism. Bigotry against anybody is bigotry against everybody, and we have to end bigotry. And there's no excuse for any kind of bigotry against anybody of the Catholic faith. Hey, John from California, what's your question?
I just saw your recent episode where you proposed certain limits to terms for Supreme Court justices. I agree that there needs to be more checks and balances on the Supreme Court. I understand there's only been one unsuccessful impeachment of a justice in our history. I wanted to get your thoughts on some other, job-based restrictions, right? Like, let's say, if a Supreme Court justice misses X number of days of work, due to, sickness or, any kind of means, or, X number of late days, or if they're, falling asleep on the job during arguments, we could let that happen for, Y number of times before, they're forced into retirement, right? You did recently say that, Ms. Ginsburg had the acumen, the mental acumen to perform her job, throughout her entire lifetime. But, I think physical condition, that affects performance should, also be considered, right? Thank you very much. Have yourself a good day.
Thanks. Great question. There's a gaping hole in the Constitution. It provides under the 25th Amendment for what happens if a president gets incapacitated. It provides nothing for when a justice or a judge becomes incapacitated, particularly a justice. We've had justices of the Supreme Court serve in one case after he was diagnosed as incurably a lunatic. So we had a certified lunatic serving on the Supreme Court of the United States. That shouldn't happen. But there's no provision for eliminating justices who are incompetent. We've had some justices who have been basically over the hill, who have begun to suffer from dementia. I've argued cases in front of judges who just couldn't follow the argument. Older judges. I had one case once where a judge had the wrong case and started asking me questions about a case that was not the one I was arguing. And I had to very politely remind the judge about the facts of my case. So this is a serious problem. But on the other side, we don't want to give anybody the power to remove judges for political reasons. In my lifetime, there have been efforts to remove Chief Justice Earl Warren because of his desegregation decision. Impeach Warren with signs all over the South. And there were efforts to impeach Bill Douglas, Justice William O. Douglas, who was a very liberal justice. We don't want that ever to happen. So striking the appropriate balance between a constitutional amendment that provides for a process for declaring a justice disabled and not allowing a justice to be removed because of disagreement with their political views, it's a hard balance to strike, but we have to do it. The next caller is from New York.
Hi, Alan. Thank you for everything. Standing up for America. My name is Mr. Fasten, calling from New York. I saw your YouTube where you explain, is it ethical, or if the president proposes who should be the Supreme Court justice, and then the vice president should decide if it's a 50-50 tie. It's the same thing with every law. The president's going to send the vice president to break a tie, and then he's going to sign it. It's just the opposite way. So what's the difference? Thank you.
It's an excellent question, and there may not be a difference, but there are those who argue that there's a difference between a law, because a law is something that the legislature does, and then the president has to either sign it or veto it. But here you have the president making the nomination. The president picks the justice, and then the president essentially gets to cast the deciding vote about whether to consent to his own appointment through his vice president. Obviously, the vice president will do the bidding of the president. So the president, it is argued, has too much power if he can, A, make the appointment, and then cast the deciding vote to consent to the appointment. There's no law on this. We don't know what the answer is. It probably won't come up this time because it seems like the Republicans at this point have 51 votes. If they lose one vote, and if it became 50-50, we would then have to confront that complicated and difficult issue. Jameson from Texas, what's on your mind?
I was just wondering what the purposes of Supreme Court nomination hearings now, when it appears that it's no longer about finding out about the character of the Supreme Court nominee, but more so about getting political points and trying to win elections on either side. And what would you suggest as opposed to nomination hearings? Because right now, Bork looks like a tame Supreme Court hearing, and that used to be the worst. So thank you very much. Have a nice day.
Thanks for your question. This may surprise you, but until relatively recently, certainly the last 50 or 60 years, until relatively recently, there were no hearings. There were no questions of the candidate. There might be written questions, but there were no hearings, and certainly no hearings that were on the radio or television. Today, the hearings have become a spectacle. The hearings regarding Judge Kavanaugh were really a disgrace, I think, based on unfounded charges, sullying his name in front of his wife and children and parents. It wasn't particularly relevant to his qualifications to be a judge, whether as a teenager he had gone over the line. I just think that the hearings have become a political theater show, and they make very little sense. If you ask me what I think should happen, I think professionals, maybe staff members, but maybe just bar association, should question the candidates about their judicial philosophy, about the history of their writing, and should make a report to the Senate. And the Senate could then maybe ask some additional questions in writing. But I completely agree with you. I think the hearings have made the Senate look bad, made look bad, and make America look bad to the world. The other possibility is to just improve the hearings, but you'd need both sides to agree to that, and we're not seeing both sides agree to anything. The hearings have become a blood sport, not a way of learning about candidates. So I think you're right. The hearings today serve very, very little purpose. Hey, thanks for your great questions. Keep them coming, please. They don't have to be questions. They can be comments, criticisms, attacks, you name it. Keep them short, but keep them interesting. Today we looked at one of the most controversial cases, driving people to the streets, demanding justice, Breonna Taylor. As I promised you, you'll never be bored. Call our listener line at 216-710-0050. I want to hear your questions, your comments, your criticisms, and your opinions. Remember, all calls are recorded, and we reserve the right to use your questions and comments on the air. Once again, the listener line is 216-710-0050. I look forward to hearing from you. The Dershow is available on iTunes, Spotify, or wherever else you get your podcasts.